Hey everyone, we are back. Second stream of the day. Although I was telling the Twitch earlier that I don't know if I count the first stream. It was kind of just like, oh my god, hey, are they back with a verdict? No, just kidding, they're not. So the judge has been asking the jury if they want to go home early every day. And interestingly enough, we got an update about 20 minutes ago. The jury said, no, we want to stay another half an hour and continue this. And it's like, do they really think they can achieve a lot in 30 minutes? Are they talking about the lesser charges? Or is there one evidence, one fact that they're focusing on and they just want to clear it up before the weekend happens? I don't know. Hi, Patty Cat. How are you doing today? How's it going? Hello. And you can tell I rushed to hop back on because usually when I do that, my thumbnails are not, well, they're kind of just one picture plopped on there. I have a picture of Karen Reed on my thumbnail right now, but oh my gosh, if I was Karen Reed, my heart would be like boom, 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 boom. Might die of a panic attack or something. That's crazy. But I hope you guys are doing well today. Thanks for popping in earlier. It's going to be a short YouTube stream today. So I don't think the jury's going to come with a verdict in the next 5 minutes. We're just waiting for them to come back from the courtroom, but I'm assuming they're probably going to get dismissed for the day. If they came out with a verdict, I would be very suspicious of it because imagine telling the judge that you guys can't come to an agreement and then 3 hours later, it's like, whoa, well, actually, we have a verdict. But I don't know. Maybe they decide on a lesser charge. Maybe, I don't know. Maybe there was one fact that they just wanted to work it out till the rest of the end of the day. And that's it. Hi, Chris. How's it going? Hi, Morton. Hello again. Yeah, hi, guys, again. So I'm just waiting for the court to come back. We got 4 minutes. All I know is when this trial is over, I am so glad that I will not be seeing the spinning fan again. Unless it's a mistrial and the state decides to retry this case in the next couple, I don't know, within the next year, maybe. Oy, oy, oy. I hope they're not doing that, okay? Fire says probably they are beating up the juror that's holding up. No. I don't know. I do want to know what the ratio is, though. I wonder if it's a bunch of people who think Karen Reed is not guilty and there's like a couple holdouts, or is it vice versa? I'm very curious. I would think that it would be a lot of people thinking that she's not guilty, and then maybe a couple few that are like, no, she's guilty. She says, I hit him. And, you know, they believe Trooper Paul's testimony. Or maybe they don't really care about any of the crash reconstructionists' people testimony or the medical examiners or the pathologists. Maybe they're really just hanging on to the possibility of Karen Reed saying, I hit him. But I mean, honestly, to me, the I hit him thing doesn't really mean much to me. Because at the time, maybe she genuinely did think that she possibly did, but it doesn't show that she did. Hi, Dia. How's it going? Hi, Lisa. Thanks for popping in. Hi, glad you're keeping us up today. I knew some people were pro-cops. Oh, yeah, there could be some people in the jury who are pro-cops as well. I don't understand when to accident reconstruction testify that he was not hit by a car. Not. Hi, V. How are you doing today? I'm going by the crash reconstructionists that worked for ARCA, the mechanical engineers, plural, singular. And I'm going by even the state's own medical examiner. We didn't really get too much from that. We just didn't. In terms of the state proving their case. What we did hear was, well, you know, the medical examiner saying, yeah, this isn't classic signs of pedestrian collision. So, I mean, we could think, maybe there's someone in the jury that thinks that, okay, well, since this is not a classic sign of a pedestrian collision. Oh, wait, hold on a second. There's an earthquake going on. The fan is shaking right now. Maybe they think that John is just the exception. And they believe that Karen Reed really hit him. I don't know. It would be really hard for me to vote guilty, especially when we have witnesses on the state side that didn't really prove that Karen Reed did it, you know, in my opinion. So yeah, I don't know. I really wish we could be a fly on the wall in the jury room. You know, I wish we could go spy on them because I want to know what they're talking about. I want to know what they're arguing about. Sadly, I think John will be the only person who will ever know what really happened. And you know what? I don't even know if he even knew what happened to him. I don't know. What if he was just really drunk, right? I don't know how much John drank that night, but I mean, I was trying to calculate the based on the totals that we had for the receipts and how much a Tito's. Why is the camera shaking so much? And based on how much a Tito's vodka is, was like $10 and a beer was like $5. I don't know. Maybe John was just really drunk too. And then we saw towards the end of the night. I mean, it's possible that him and Karen could have shared drinks at the second place. Or like, have you guys ever been so drunk that you just want more alcohol in your system? This is me in my teenage and like early 20s years. Okay, it's really gross. But when you're so drunk and you start running out of alcohol, you start looking around to see, okay, where are the unfinished drinks? I'm going to start drinking out of it. I'm so sorry. I probably just gross you guys out, but that was me. Okay, if I'm finished with my alcohol and there's nothing left, I'm going to start looking for some cups that still have alcohol in there or some beer cans that has alcohol in there because my drunk self just wants more. But yeah, I mean, I don't even know if even John knows what happened to him. Maybe he does, maybe he didn't, or maybe he does, maybe he doesn't. My opinion is she did hit him accidentally because she was drunk. Yeah, there are some people who think that as well. My issue was that because that's honestly where I was going. I was like, oh, maybe she hit him accidentally and she didn't realize because she was really drunk. He was drunk. What really changed my shift from that mentality was just the experts saying the lack of bruising and the fractures, especially if the car was going 24 miles an hour. So, yeah. Wow, learned a lot about Corgi today. What did you learn? That I used to be disgusting when I was in my teens and early 20s? Yeah, I was. I was so gross. Okay, I used to smoke cigarettes too. The camera's shaking below because there's a brawl going on in that church scene in Kingsman. Oh my God, that movie is so good. I love that movie. I don't know. I mean, they're supposed to be back right now. Do you guys think that they're going to, I don't know. What if there were, oh gosh. I wonder if, I think this happened in the Nicolay New case where there were some people who wanted to go for the serious charge and some people who were like, I'm not convinced all the way. And then they chose like a midway point where it's like, okay, fine. We'll just compensate and just choose the lesser charge. Because the thing about the jury asking the judge to go to 415 was really odd to me. I was like, oh, are they just gonna choose a midway point, which I think would be weird here. Hi Sarah, how are you doing today? You're here for the verdict. Hi Sherry. I don't think there's gonna be a verdict today. If there was a verdict and 3 hours ago they said they couldn't come to a unanimous decision, I would be side-eyeing pretty hard right now. Like, okay, so how is it that 3 hours later you guys change your mind? I don't know. And then something tells me that the jury really wants to enjoy their weekend and next week not have to come back during the 4th of July week. Because we have 4th of July on, that's Thursday. I mean, gosh, I don't know. I wonder if the jury's mind, they just thought that they were going to be done like, oh, deliberation 4 days before the weekend. We got this. And then as each day passed, they're like, oh, shit, we might have to come back next week. That sucks. Why is the jury asking for 3 hours? Well, initially, 3 hours ago, the jury gave a note to the judge saying they couldn't come to a unanimous decision. They felt like they exhausted all efforts and I forgot what the exact language was in that note. So the judge was like, you know what? You guys go back. Please think about it. Eat your lunch, and do some more thinking. And so when the judge asked them, like, hey guys, it's I don't know, like 3:45 maybe. She's like, hey, do you guys want to leave early for the day like you usually do? And they're like, no, we don't. We want to stay for another extra 30 minutes. And I was like, oh, that's kind of weird. I think that's weird. And the camera keeps shaking. I want to know what's going on here. We got the fan. We got, what is that, a smoke detector? And then we got what is this guy over here? And what is this guy? Oh, wait. Are we ready? Karen Reed's parents are here. I really want to know what they think. Or sorry, not Karen Reed's. I meant to say John O'Keefe.
So, jurors, we all know how hard you've been working. It's been a long day. We're going to let you go home. We'll see you Monday morning at 9 o'clock. To the extent that you can, please just not think about this case this weekend. Clear your heads. We'll start fresh.
That's going to be so hard to not think about this case over the weekend. Oh, man. Can you imagine if some of the jury members are getting pressured by their family members to like get out of jury duty so they can enjoy 4th of July and the holidays and all that stuff? I don't know. Like, I hope not, you know? I know it's like, I don't know.
So
What if they're thinking of ways to get out of this?
please follow those instructions. Do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it. We'll see you later. Thank you.
All rise for the court, please.
No verdict. John O'Keefe's brother. This case is killing me. Yeah, it's draining my soul. Oh gosh. I can't wait to hear the tea after this is done. I can't wait to hear from the jury. I want to know the tea behind all of this. It's crazy outside of the courthouse. I saw a little clip of
Thank you. Be seated. Court is still in session.
All right,
people
we'll see you
outside.
Monday morning. Thank you.
Thank you, Your Honor.
Oh yeah, that's a lot of people out there. Oh man. Karen and her team look very unhappy. I mean, it's just nerve-wracking. You got the rest of Friday, you got Saturday, Sunday, you gotta come back Monday. Oh my gosh, it's just so nerve-wracking. Do you guys think if there was a mistrial and they were to retry it, do you think that'll be better for Mr. Lawley, or do you think it will be better for the defense? Hi, Jesse. It's a big story. Risky that the jury won't say anything over the weekend. They probably can't catch the local news at all. Oh, man. I don't know. Them having to think about this over the weekend. So much stress for everyone. Yeah, it's stressful. Your friend drove by the courthouse. Cops are handing tickets to anyone who drives by and honks. That's a lot of tickets you would have to give. Seems kind of dumb. Better for Miss Lawley will have time to rearrange a witness. Even if Lawley rearrange his witness, I think it would help him a smidgen. So, like I was saying, I think it helps to have someone to give like a clear picture, a timeline of what happened, and then someone to explain the injuries and someone to line up those injuries with how, you know, they could have happened with the vehicle, right? But yes, it would have been helpful to have, you know, I think the paramedics going was good, the law enforcement going, and then the family members going good. And then maybe doing like the Jen McCabe, Carrie Roberts, medical examiner, like all like kind of like in the beginning, I guess. I think would probably be better, but I don't know if it really helped it much though. Cause remember, I don't know. Cause like when we heard from the medical examiner, it's not like we got more answers. I mean, the medical examiner, her finding was that, you know, hypothermia, blunt force trauma. She doesn't think there's any signs of a fight. She said there's no other, like, you know, DNA in the fingernails. It didn't seem like his knuckles were all fucked up. The 2 black guys that he had was probably a result of the skull fracture in the back of his head. But like I said, we didn't really get much answers in terms of how the car hit him and how the injuries line up and all that stuff, you know? I don't know. Like, I don't know if Lawley would even want to retry the case. Maybe. Because I guess, like, at this point, maybe, you know, he's at stake because people are pointing fingers at him, his office, the judge, the law enforcement. So maybe it's like they got to stand their ground and they really got to prove that, like, oh, we're not in on this, blah, 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 and stuff, right? But I don't know if they would want to retry this case. I just don't see how, I don't know. A lot of the experts that testified, the ones that I was looking forward to hearing from, crash reconstructionist guy, for example, when they went up there and testified, I was just like, oh, you know, this doesn't feel like the greatest testimony. A $40 ticket? Oh my goodness. A $40 ticket? Why was the background look like old blood? I don't know. They switched from him having this background, or sometimes he has like a really cool library background. Do you guys want to go back to the fan? There you go. I know you like the fan. We could look at the judge, I guess. Let's look at the judge. Or maybe the people in the gallery. Wait, where'd it go? Oh God, I lost it. Honestly, I think it'd be better for the defense if they got another chance to retry this. But oh my God, it's going to be so expensive for Karen Reed. I know she has maybe like a crowd fund and people are donating to her legal defense team and stuff like that. But I don't know how much money she's getting. But, you know, maybe if the federal investigation is done and there's more information that shows that, okay, well, John O'Keefe didn't die in XYZ way, what the crash reconstructionist guy says seems to be what the investigation is aligned with, then yeah, that could look really good for Karen Reed. Hi, Wayne. How are you doing today? I thought they meant tickets to the trial. That's what I read initially. I was like, cops are handing out tickets to the trial. Wait, what are we talking about? No, tickets, I guess if you're passing by and you're honking. That seems kind of weird. Hi, Yoshi. How are you doing today? How's it going? Morrissey may say retry a hung jury's political death for the DA. Also, you know, Lolly should be like, Morrissey, I want you to come in here and fucking help me with this. Where's Morrissey at? Is Morrissey trying another case right now? Where is Morrissey? I can't believe Lolly had to do direct examination for how many witnesses did he have on the stand? 60 to 70 witnesses? Oh my goodness. I was like, where does Lolly not have anyone else helping him? That's so crazy to me. She wasn't kicked out of the trial. Who wasn't kicked out of the trial? Some say Reed may not be able to afford those attorneys in case of a retrial. I mean, I know she has a crowd fund. I don't know. I don't know if they would do it pro bono. That could be a thing. Or have one attorney. I don't know. I'm not too sure. I'm doing good. Happy Friday. Hope you and Shira are having a great day. He's over here. He's passed out right now. He was being so naughty at pickleball yesterday. He was barking while we were playing. He was like barking at us like to like hurry the fuck up and go home. I think he was getting a little cranky. He was getting a little tired. It's better for the defense, more testimony to cross. Yeah, I think that's good too, because there was a lot of issues with the state's witnesses when they testified. And so now they have more testimonies to work with, right? There was the grand jury. I think there was a second grand jury, and then there was a federal grand jury. So now they could be like, oh, well, you know, you said X, Y, and Z during this trial, and we're going to use this to impeach you and show that you're lying or you're inconsistent, or maybe your memory's not good. Do you have an issue with your memory? Do you have a problem with your memory? I think he was just being like a cranky old man. Yeah. He's at home arranging his Mr. Potato Head collection and dancing to the 80s love ballads. I don't know. It's not his fault there's a ball getting bounced around and not going in his direction. He actually doesn't like balls. It's weird. When we used to play tennis initially, he used to love chasing after the balls, and then he kind of just got over it. Yeah, I want to know what Morrissey's up to. What is Morrissey doing right now? Morrissey's like, okay, Lolly, have fun. Goodbye. Good luck against Mr. Jackson and Mr. Jackson and Mr. Yannetti. Good luck. Oh, man. Okay, so they're going to come back on Monday. Jury's going to come and deliberate, and I just can't wait to get the tea on this jury. I hope there's not going to be a gag order or anything. I hope after this they can talk to the public, do some interviews, and we can really get the tea on, okay, so we want to know, who were the holdouts? What were they holding out on? What were you guys arguing about? What were some statements that you thought were good from the defense or from the state? Right? Oh, man, I just want to know so much. I think it'd be really interesting, especially since these people in the jury are, you know, not supposed to, but they haven't talked to other people. It's just all amongst themselves. Hi, Hocus. How? How? Hi, I like how you just come in with that energy. How? I want to know about the juror that was supposedly crying. Oh, there was someone that was crying? I don't know if I heard about a jury crying. What do I think about the Dr. Disrespect drama? Oh, well, I mean, this is what I've said so far. For the Dr. Disrespect stuff. It's just crazy to me how the mystery of what happened to him and why he was banned from Twitch, it was like such a huge mystery for like 2 years or some shit. And then in the end, it just ended up being your typical content creator texting or DMing a minor shit. It's just like, oh, well, geez. I don't know. I don't, it's like always the same shit. It's like cheating or you're texting a minor. I don't know. Or like a mix of those two, right? Hi, Nicole. How are you doing today? Just a recap for the day. So the jury was deliberating for about like 3 hours today, told the judge, hey, you know, we can't come to a unanimous decision. And the judge is like, okay, well, I feel like you guys can probably work on it a little bit more, eat your lunch, go back and deliberate some more. And so they did that. And then so they deliberate for another couple hours, and the judge sends them a note saying, hey, do you guys want to get out early for the rest of the day? And the jury was like, no, we want to stay here for another 30 minutes. And I was like, 30 minutes? What do they get done in 30 minutes? Are they close to coming to a unanimous decision? Are they going to, or are they just going over like one evidence and they just want to be like, make sure they're clear about an evidence or something like that until the day ends? Or are they going to compensate? Like, what's going on here? But no, they came back, and then the judge is going to bring them back on Monday. Hey, Tuko, how are you doing today? Office Secretary Shiro's on a lunch break, and it's taking a very elongated lunch break. We always make a joke saying that Shiro's just on PTO. But I say that about Steve now. I feel like Steve is on PTO. You never know when he's going to come back. So, yeah, I don't know. They're going to come back on Monday and deliberate. Compromise is the word that Corgi is looking for. What was? Did I say something else different? I don't know. This trial just boggles me. I had a couple nightmares because I would wake up at 6 a.m. I would leave this on my iPad, and I would periodically check to see, is the jury gonna? I'm just going back to sleep. So I kept dreaming about the jury and all that stuff. One dream that I had a dream that the foreperson told the clerk that they absolutely found her not guilty. And then the clerk announced they absolutely found her guilty. And then the judge was like, oh, it's a mistrial because you said it wrong or something. And then in my dream, I was crying because I was like, oh my God, I don't want to have to go through this lolly shit all over again. The second oh my God. I was like, please no. Doing this all over again with Lolly. I don't know. In my dream, I was really upset. I woke up and I was like, oh gosh. Oh, never mind. The jury has not come to a decision yet, so we're good. I think she's just like messing with us at this point. Who, me? I mix words up sometimes. It happens. I think they are hung. I think they just don't want her to say, I think they are hung. I think they don't want her to say they have not put in, the time. Hello. Yeah. I don't know. Maybe they are sitting there just twiddling their thumbs, but maybe they are really trying, Maybe they are trying. Maybe they're trying to really convince the other side that like, hey, maybe you remembered this wrong. I'm just not surprised. Sorry. I'm surprised that they're not asking the judge for maybe like readbacks of transcripts or or like listening to like some of the recordings or something. Actually, no, all the recordings kind of suck, but maybe like a readback on transcripts. Because for me, when I was looking at my notes, there were some parts where I was like, oh, did I take this note correctly? I'm not sure if I did. And I would go back to the YouTube channel and refer back to that and make sure that I listened to it correctly the first time. I could sue Lolly for emotional distress. Does anyone know what would happen if she was found guilty and then the feds prove it's someone else? Well, I would... if the feds proved that it was someone, I don't know if they would really go into that deep of investigation. I think the feds are just trying to prove that, okay, could this have happened to John O'Keefe? But let's say if they covered some new evidence that for sure, 100%, that it was not Karen Reed and it was someone else, I'm sure they'll bring it to the state, and then the state would have to do this whole thing where they overturn it. And yeah, it's like probably like a whole ass fucking process. But it would probably have to be something that's like for sure, they have that it was someone else that did it, right? Like, oh, maybe there's like a camera that shows that Karen Reed left the area and then John O'Keefe was there and then something else happened to him. I was talking about, the judge messing with us, calling us back for nada. It will be overturned on appeal. Because I don't know if it was found that someone else did do it, I don't know if they would have to go through the appeal process. I wonder if the state could just be like, oh shit, they're like, we'll just have to reverse the charges. But yeah, I want to know what's going to go on with the federal investigation. Like the 3,000 pages that was released. I was trying to find them. I couldn't find them. I would love to read 3,000 pages of what the feds found. But I mean, it seems like the defense chose what, worked for them the best, which is having the two ARCA guys come in and testify. But what was astounding to me, I was reading this time frame of how everything unfolded. And the issue that I had was there were some statements that the state made about, the Fed report is out, but I mean, only 10% of it disagrees with what we said. Most of it is aligned with our case. But it's like, okay, so you're saying the 10% that disagrees with you is also something that's like major in the case, because, you know, the 10% that you're referring to are the ARCA people who said that John O'Keefe was not hit by a car, the injuries are not consistent, the taillight damage is not consistent, XYZ, blah, blah, blah. I don't know. So there's like so many weird shit about this case that I was reading online before the trial happened. Hi, Band Bus. I think if they did find someone else did it, it still has to go to court. Yeah, because I would assume what would happen is if it was like 100% sure, probably like reverse the charges on Karen Reed, and then the state would have to try that person. But I don't know what the order would be. Would it be like they have to try that person first and find them guilty, and then go after, and then, you know, reverse the charges on Karen Reed, or, you know, not quite sure. The feds are spending all the time and money to decide for themselves if she did it or not. I just want to know the outcome of the investigation. I miss Shiro and Steve. I miss Steve too. We're getting very close to Steve's death day. And I'm like, oh my gosh, if it was a year ago, I wouldn't have known that Steve was going to die soon. Ah, Steve, I miss you. Yeah, I miss Steve all the time. I miss my little bubby. My little bubby. He was always getting into trouble. Oh man, I wish I had the article with me on hand, but oh, just the whole thing's just wild. If you guys ever look at the timeline of after John O'Keefe was found, and then like up until now, the timeline stuff is really, really, really interesting. Chloe needs to go behind bars. Well, some people aren't even sure if Chloe is even in existence anymore. They think she might be on a fireplace mantle somewhere. Or maybe she could be where, you know, what did they say? They rehomed her somewhere in the East Coast or something? Maybe someone can find Chloe. All right, well, yeah, I know. That's it for YouTube, really. I was gonna, I don't know if there's anything else we should cover. Kohlberger had a mini hearing about, was it yesterday or 2 days ago? They have a trial date set for June of 2025. We'll see if that happens. It seems like the judge really wants to move this along, but the defense is like, we have a shit ton of discovery. It's just a lot of stuff to sift through. Oh, is it New Hampshire? Gotcha. Okay. Yeah. I don't believe Lolly for a second that it was only 10% was different. I'm trying to see if I can find the article, but I think I was reading it on my phone. I don't know if it's linked to my, let me see if I can find it actually. Because I think on my phone I have a different, oh, maybe we can read some of these articles. I thought these were kind of interesting. Oh, I thought this was interesting actually. Because I really wonder how it is in the local community. This case must be a shitstorm for them. Canton residents vote to audit police department over John O'Keefe murder case. This is in November 2023 of last year. At a special town meeting Monday night in Canton, Massachusetts, residents voted to audit the police department over a controversial murder investigation. Let me make this bigger for you guys. Can I get rid of all the ads? Yes. More than 1,700 people showed up on a vote to vote on a topic that has divided the town. The investigation of the death of Boston police officer John O'Keefe and the murder charge against his girlfriend, Karen Reed. In the end, participants at Monday's meeting voted 903 to 800 in favor of an audit of the Canton Police Department. In an earlier round of voting by hand, an audit passed, but that was formally challenged, leading to a second vote. I mean, Proctor works for the state. They might need to do something about the state police too, man. A vote of no confidence in the police department was also withdrawn late Monday night. Canton native Kathleen Howley spearheaded the effort by creating a petition that ended up getting well over 300 signatures to trigger the vote. Quotations. We are really up against something here in Canton, and a lot of us don't understand it, said Howley. O'Keefe's body was found January morning in 2022 outside the home of Brian Albert, a fellow officer with the Boston Police Department. The night before, O'Keefe, Reed, Albert, and others drank at a bar before returning to Albert's home, where Reed told police she dropped O'Keefe off. Prosecutors said Reed hit O'Keefe with her SUV and left him to die. She has pled not guilty, and her defense attorneys have alleged a large-scale cover-up. Also, do you guys think it was helpful for the defense to really lean on the cover-up during closing arguments? Or would they have been better off just focusing on the reasonable doubt? Chloe has been rehomed 6 feet under. They're going to bring in the new defense that Koberger was mind controlled by aliens while he was stargazing and went on a murder spree. I watched one of the hearings that they had. I think it was about 3 hours long. It was a couple weeks ago. That seemed pretty significant. There was an expert that said that the way the police were able to track Koberger using his phone seemed a little bit sussy. I didn't take notes on that, and I wish I did take notes, but it seems like, I don't know. There might be some questions with how the police were able to track Koberger using the phone. Like, it may not have lined up with the way it seems to have based on the arrest affidavit. Because when we read the arrest affidavit, it seemed pretty clear and cut, but there seems to be some issues. Hi, Trash Panda. How are you doing today? Sarah Boone. Is there updates with Sarah Boone? Sarah Boone. Did they? I know the attorney requested to withdraw, and I will lose my shit if she tries to represent herself. No. Let me see. If there's any updates with Sarah Boone. What? No, the judge, stop it. Oh no! I'm seeing the notes. No. Wait, was there a... Oh my lord. No. I don't like it when they represent themselves because they usually don't know the law. It holds things up. It's just messy. I wanted to just move smoothly and let them have someone to represent them. But you know, I get it. No one wants to represent her because she seems like impossible. Is there a Sarah Boone hearing that was live streamed? Sarah Boone filter today. Gosh, Sarah Boone. I don't know if they live streamed it. Oh gosh. Okay, let's look at the Sarah Boone stuff really quick. No, I don't like it when they do that. It's just gonna be a shit show. I would hate to be the jury on that case. She's not gonna know what the fuck she's doing. Oh boy. Oh gosh. Okay, here are some comments. Court minutes, motion to withdraw. Okay, so the update that we had, Patricia Cashman, her 8th public defender, her 8th attorney, and who is a public defender, asked for the motion to withdraw. Okay, so we have the correspondence, 58 pages. The motion to withdraw was done on 6/11. They had a hearing on 6/28. Oh gosh. Okay, let's look at this. Oh boy. Oh boy, oh boy, oh boy, oh boy, oh boy. Oh, okay. I actually do want to read all of this if you guys are cool with that. This cause came before the court on June 28 on defense counsel Patricia A. Cashman's Esquire motion to withdraw as counsel filed June 11, 2024. The court has reviewed the motion and, having reviewed the court file, having reviewed the audio transcripts from various hearings, have considered the positions offered by counsel Patricia Cashman Esquire, having considered the testimony offered by defendant Sarah Boone, and having considered the positions offered by counsel for state, hereby finds charges. A. On March 23, 2020, by way of information, the defendant was charged with second-degree murder. That was almost 4.5 years ago. 4.5 years ago! Can anyone be as bad as DB? Yeah, Sarah Boone. I think Sarah Boone's pretty bad. I think she's pretty bad. B. February 26, 2020. The Office of Public Defender, 9th Judicial Circuit in Fort Orange County, Florida. The public defender and attorney number 1 was appointed to represent defendant. On March 9, 2020, the public defender moved to withdraw due to defendant retaining private counsel. Yes, Mauricio Padilla. Now, Mauricio Padilla was her attorney for about 2 years, I think, and then all of a sudden withdrew. And I was like, what happened here? Oh boy, maybe she ran out of money or something. Or maybe there was a conflict of interest. Or sorry, not conflict of interest. Maybe there was, oh gosh, what's the word that I'm looking for? Not conflict of interest. Now my brain is all fucked up. Maybe conflict of, what am I thinking of? Maybe there's a conflict between the two of them. There's a better way to say that. You're welcome. Here comes another DB case. I know. Why won't they hire DB to represent her? Summon him. Maybe he will. Okay, summon him. Oh. Irreconcilable differences. Thank you. On March 11, 2020, that certain order allowing withdrawal was entered, which withdrew the public defender from further representation of the defendant. Okay. On April 18, Padilla moved to withdrawal. So yes, 2 years later, due to irreconcilable differences. I mean, at least he worked with her for 2 years. Oh man, he was probably like, "No, this ain't worth it. This ain't worth it for me." Irreconcilable differences arising between undersigned and defendant that has made it impossible for undersigned to effectively represent his client. As always, it's difficult to convey all particulars to the court and at the same time maintain all duties to the client. I don't know. Maybe all the attorneys need to get together and have like a therapy session about Sarah food. This motion was served upon the defendant, and the defendant confirmed receipt. Oh boy. So that's one that withdrew for irreconcilable differences. Okay. On April 29, 2022, a hearing was held on Padilla's motion of withdrawal. At the time of this hearing, Padilla has been representing defendant for over 2 years. Defendant was present for the hearing and was sworn. The court advised Padilla the court received a letter from the defendant, a letter dated April 20, 2022, filed on April 26, 2022, which seemingly objected to Padilla's withdrawal. Oh no, she wanted to keep him. She's like, no. The court advised Padilla that the options were to not proceed on Padilla's motion of withdrawal or provide the court more about the irreconcilable differences. Padilla requested an opportunity to amend the motion to address the irreconcilable differences. The court reserved ruling on Padilla's motion of withdrawal, gave Padilla until May 3, 2022 to prepare and file an amended motion with the hearing to be heard on the week of May 9, 2022. Where are my glasses? I don't have my glasses here. The state advised of Padilla's diligence and preparation. The court commended Padilla's work. Defendant testified to a lack of trust between herself and Padilla. On May 4, 2022, Padilla filed an amended motion of withdrawal, which supplemented the original grounds. Undersigned's relationship with the defendant has become adversarial. The aforementioned adversarial relationship has interfered with undersigned counsel's ability to effectively represent his client, especially preparing for trial. 2, undersigned appreciates the court's providing him the opportunity to amend his previously filed motion of withdrawal. However, after further researching the issue, undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client, and as such will stand mute on the specifics. Oh boy. So he filed a second motion to withdraw, and I'm sure it was granted. The undersigned relationship with the defendant has deteriorated to the point where undersigned counsel can no longer give effective aid in the fair representation of Miss Boone's defense. Oh, man. Oh, boy. Okay, so on May 10, a hearing was held on Padilla's second amended motion of withdrawal. Defendant was present for the hearing and was sworn. Padilla advised the court that he had no other choices to file the motion due to ethical concerns. Should I start taking notes? Oh, gosh. Let's see. So attorney number 2 for you guys, Padilla. Should I do does that make sense? Irreconcilable differences and ethics. Oh my goodness. Oh boy. Okay. Ethics. Where was I? So she didn't want him to withdraw, but I guess at some point agreed. Deteriorated. Ethical concerns. Okay. Defendant confirmed that she wanted to terminate Padilla as her attorney to represent the terminate Padilla as her attorney. I think someone said they're all breathing oxygen too, but I can't say that's 100% right. Wait, what are we talking about? Attorney equals incompatible with narcissistic asshole. The court advised defendants of the state's concern regarding a strategy defendant being unhappy with every attorney and advised defendant about the dangers of self-representation. Wait, what? Hold on. Did I just skip a couple pages? Did she want to represent herself? Okay, I feel like we jumped somewhere, but we didn't. The court advised defendant of the state's concern regarding regarding a strategy defendant being unhappy with every attorney and advised defendant about the dangers of self-representation. The court appointed the public defender number 3. So this one withdraws because there's a conflict, not her fault. Number 7, on June 7, they allowed the public defender to withdraw. On June 10, they appointed attorney number 5. They wanted to withdraw due to conflict. And then entered Frank Bankowitz, attorney number 6. On July 12, 2022, Bankowitz in open court requested a continuance due to his recent appointment, and same was granted. Thereafter, the court set a pretrial conference for October 25, 2022 at 9 a.m. and trial during the trial period beginning November 7, 2022. God, this is 2022? Wow, time flies. Time flies. The court held a pretrial conference and addressed the court's understanding that a continuance was being sought, and the court's judicial assistant was reached out to the parties to confirm if a continuance was being sought. Excuse me. On October 27, 2022, Bankowitz filed a motion, defendant's motion to continue. On October 28, the court entered that a certain amended order of defendant's stipulated motion to continue, which set a pretrial conference for January 17, 2023. Oh, man. At 9 a.m. And the trial during the trial period beginning January 3rd, 2023. Yep, I remember this time period. The court set a status hearing on Tuesday, December 20th, 2022. Bankowitz moved to withdraw due to irreconcilable differences. So this is attorney number 6, right? I think. Bankowitz, yes. Attorney number 6. Bankowitz. Same thing. Irreconcilable differences. Reconciled differences has been arisen between the undersigned, his client, his family, and the undersigned will be unable to effectively and properly continue representing the defendant herein. On December 20th, I think, he was in a car accident. Oh, is that what happened to him? Status hearing was held. Bankowitz did not appear due to a car accident. The court reset the status hearing for December 22, 2022. I think initially they declined his motion to withdraw. But then he did it again a couple months later. Yeah. He did it again a couple months later, and they're like, okay, fine, you could go. On December 27, 2022, a hearing was held on Bankowitz's motion to withdraw. Defendant was present for the hearing and was sworn. The court advised defendant that the court had received letters from the defendant dated October 3rd, filed on October 7, a letter dated November 3rd, filed November 7, and a letter dated December 5th. The court conducted a Nelson hearing, and defendant was not seeking to remove Bankowitz. Bankowitz advised the court of thousands of pages and discovered that he had reviewed and organized, and his contact and potential use of and collaboration with expert witnesses, including experts that Padilla utilized. Bankowitz advised the court of defendant's attempts to call Bankowitz at a rate of 5 to 10 times a day. I don't know if we heard that. Was this in writing or something? I don't remember hearing that in the hearings. Bankowitz further advised of his efforts to balance the demands of other clients with the defendant's expectations for communications. Now remember, because we've only heard from Sarah Boone's perspective. Sarah Boone's perspective was like, oh, my attorney is not reaching out to me. We haven't talked. My trial is coming up. This is a huge fucking issue. But again, we're only getting it from Sarah Boone's side of the story. In response, the defendant reposted that Bankowitz's representations were untruths, raised Bankowitz's prior public reprimands for lack of communication, alleged Bankowitz's action in this case arose to a similar level, then sought to remove Bankowitz. The court appointed defendants' inconsistent statements within minutes of them being made and addressed concerns over defendant's motion. Oh no, they said she made inconsistent statements. Especially when there is something the defendant disagreed with. So I think the court knew. Well, sorry. During this time, she had a different judge. I forgot what the other judge's name was, but she had a different judge and a different all the different attorneys. Oh man, the court specifically advised the defendant that she is not entitled to an endless line of court-appointed lawyers until you find one that you personally prefer. Oh man. The November 3rd, 2022 letter sets forth ad hominem attacks on Bankowitz's professionalism. See page 2. We read the letter. December 5th letter sets forth ad hominem attacks on Bankowitz, including severely misled and neglect. See pages 2 and 3. Oh, they probably attached it to this. Sarah Boone, fuck around and find out. Oh, man. Taxi, how much do you want to bet? The report ended with... Nanny boo boo, stick your head in doo doo. I have never heard of that before. Is that a common saying somewhere? She's going to change her plea to unintentional. Ultimately, the defendant did not request to remove Bankowitz. Oh, the court also explained the circumstances where defendant could represent herself. She's like, oh, shit, maybe not. The court denied Banquet's motion to withdraw and directed Banquet to have a conference with defendant prior to the pretrial conference previously set for January 17, 2022. Poor Mr. Banquet. The case was continued several times due to Banquet's attempts to retain an expert through JAC and JAC's response to same. During this time period, the court has received several letters from defendant, a letter dated January 10, a letter dated March 22nd, 2023, a letter dated April 6, 2023, a letter dated May 15, 2023, a letter dated June 29, 2023, a letter dated August 2nd, 2023. On August 22nd, 2023, so we are now about 8 months later, Banquets again moved to withdraw due to irreconcilable differences between undersigned and the defendant that made it impossible for the undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. Oh gosh. Jesus. The January 10 letter, ad hoc attacks on Banquet's professionalism and morals. May 15 letter, ad hoc attacks on the court alleging, Judge Wayne Wooten was being monetarily compensated from third parties. Use information that is publicly available. The June 29, 2023 letter sets forth ad hoc attacks on Padilla, which were not raised during either the April 29, 2022 hearing or during the May 10, 2022 hearing on Padilla's motion to withdraw. So maybe they think that Sarah Boone is just making shit up as she goes. All right, let's read this part. See also defendant's quasi ex parte motion for appointment of defense forensic psychologist and request for sealed order filed July 17, 2023, and the Justice Administrative Commission's ex parte response to motion for appointment of defense forensic psychologist filed on July 19, 2023. Defendant will not be satisfied with any attorney unless said attorney does not have a caseload and can only dedicate his or her time solely on Ms. Boone's case. I mean, honestly, she had someone that she hired and it seems like there are issues there. I don't know if it's just like, I want someone to, give me all their time. I think it's, I want someone to give me all their time and do exactly everything that I say because I'm smarter than them and I'm more intellectual. We've seen her letters before where she's like, I'm intelligent. I'm not a murderer. I don't know if she's even offered a plea deal though. I don't know if I heard about anything about a plea deal. I'm sorry, I need to get some water. I need to change the title of this live stream really quick because now we're doing Sarah Boone stuff. Question mark? Okay. I've retitled. Oh man. Excuse me. The allergies are not great right now. The best possible avenue to have the defendant represent herself. As no attorney can satisfy her. On September 8, 2023, a hearing was held on Banquet's motion to withdraw. Defendant was present for the hearing and was sworn. Banquet addressed defendant's derogatory statements like dud, buffoon, and berating behavior. The court advised defendant the court has received letters from the defendant dated August 26, September 7, August 30, September 7. Oh, sorry, these were the dates that were filed. So 2 letters, August 26 and September 7. After the court's colloquy of defendant and her acquiescence to Banquet's withdrawal, the court granted Banquet's motion to withdraw and appointed Winston Hobson. Oh, I forgot about Winston Hobson. I think he also asked to didn't he also ask to withdraw as well? I think so. Oh, Mr. Hobson. Thereafter, the court set a status conference for October 30th at 10 a.m. and set a pretrial conference for November 28, 2023. I forgot about Hobson. How could I forget about Hobson? Oh gosh. After setting these dates, hi Storm, hey Roxit, The court pointing out the deterioration of the working relationship between defendant and Bankowitz. The court further cautioned that if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. The court further advised there are certain decisions that attorney gets to make and certain decision defendant gets to make, like go to trial and or testify. The court cautioned as to defendant's unrealistic expectations regarding court-appointed counsel and reminded the defendant of her right to retain private counsel. She probably has not done that because she probably doesn't have the money to hire someone out of her own pocket. On October 30th, a status conference was held. Hobson advised as his conversation with defendant and setting a status in January 2024. Oh man. Thereafter, the court set a pretrial conference status as a readiness for the trial on January 16, 2024. On January 12, 2024, Hobson filed a motion to continue, waiver of presence, and requested a 3-docket continuance. On January 16, 2024, the court addressed Hobson's motion to continue, granted same, set a pretrial conference for May 3rd at 9 a.m., and trial during the trial period beginning May 13. On February 1, oh man, attorney number 7, Mr. Hobson. Irreconcilable differences, citing ethical considerations. Man, Sarah Boone, she'd be wanting them to do some shady shit, probably. On February 9, a hearing was held on Hobson's motion to withdraw. Hobson addressed a number of issues as for the basis of withdrawing, including disagreements on legal strategy, on what can and cannot be done, a lack of resources, defendant's demands making her difficult to work with, including defendant making non-viable legal positions and being unreasonable. As to a key substantive defense, Hobson advised that the retained and undisclosed expert is not keeping with what defendant has in mind. When Hobson advised that the retained undisclosed expert is not keeping with what the defendant has in mind. God, that sentence is like so weird to me. Okay, so they hired an expert witness, and I guess the expert is not saying what Sarah wants him to say. She doesn't agree with them. Because you know why? Because she's smarter than everyone. Smarter than the attorneys, smarter than the experts. Sarah's like, no. I'm smart. I'm intelligent. I know more than you guys. The court advised the defendant that the court has received a letter from the defendant, letter dated January 19, 2024. The court outlined the overriding claims for withdrawal by Padilla, Bankowitz, and Hobson, adversarial relationships, lack of satisfaction, and inability to meet defendant's desire. The court found all of the defendant's relationship with the court-appointed counsel have deteriorated such that defendant and the court-appointed counsel cannot work together. The court advised defendant that although defendant has a right to court-appointed counsel, that right is not unlimited. The court twice advised defendant and that defendant may not be provided another court-appointed attorney, and the defendant would have to represent herself if circumstances similar to Hobson's motion to withdraw occur. I thought they were just threatening her with it. I wasn't sure if they were going to really move forward with it. The court further advised defendant about the dangers of self-representation due to defendant's lack of legal training and knowledge. Defendant never stated that she did not understand that she may not be provided another court-appointed attorney. Oh boy. The court granted Hobson's motion to withdraw and appointed Patricia Cashman, attorney number 8. Patricia Cashman. Oh, should I make this smaller? Sorry, these are notes just so we can keep track. Okay. Attorney number 8. Intelligent people have the right to remain in prison. I guarantee no suitcase company will be sponsoring. I plan to laugh at Sarah the whole time this is on trial. Yeah, she's going to be made a fool of herself. All right. So they granted Hobson's motion to withdraw. They appointed Patricia Cashman, attorney number 8. The court is aware of Cashman's extensive experience representing criminal defendants as both assistant public defender and in private practices, including representing defendants accused of murder, and is widely known to be able and willing to deal with and manage difficult clients. The court set a status hearing for April 12, 2024. The status hearing was held. Cashman advised as to the depositions that has been set, the hiring of an expert, and a request for a future status date to address a trial date. The court set a status hearing for June 7, 2024. Now on June 7, 2024, the status hearing was held. Cashman addressed her dates of availability for the trial. Defendant was present for the hearing and was sworn. Thereafter, defendant advised the court to walking out of multiple meetings with Cashman, which was confirmed. Cashman utilized a pretend judge to oversee the defendant and Cashman, launching multiple attacks on Cashman's professionalism and providing the court with letters dated June 4, 2024, June 7, 2004, both of which were filed on June 21st, 2024. Can you imagine this? Like, this sounds like so childish to me. You and a friend are fighting. You guys are like 7-year-olds. And because you and a friend can't come to an agreement, you're going to get a pretend judge to oversee the both of you guys, but the pretend judge is really just you. It's like you're giving yourself the 2-to-1 numbers on in the disagreement. But how could a pretend judge be there and be not biased if the pretend judge is actually the person, you know what I mean? Like the other person, like, I don't know, that just seems like a very childish thing to do. Like, hey, we're going to have a pretend judge and the pretend judge is going to be me. Okay. So that's totally fair. I don't know. That's like the way that she brought up this whole pretend judge thing, like as if it was like a cure-all to the issues that the two of them were having. It's like, but if the pretend judge is just you, Sarah, it's not really going to help at all. Cashman advised to her efforts and time spent on the case so far, 20 hours. Cashman addressed disagreements on legal strategy, including defendant attaching importance to issues that may not be illegally important. In riposte, defendant accused Cashman of lies and half-truths. And also she wanted to know why she can't be out on bail. On June 11, 2024, Cashman moved to withdraw under Florida rule regulating the Florida Bar 41.7b2. Substantial risk that the representation of one or more clients will be materially limited by the lawyer's responsibility to another client and irreconcilable differences, including but not limiting to ethical considerations. Irreconcilable difference, ethical consideration. Jesus. On June 8, 2024, a hearing was held on Cashman's motion to withdraw. Cashman relied on Florida rule regulating the Florida Bar for 1.7b2 and Schwab v. State as the basis for the withdrawal. At no time has the defendant refused to accept the services of any other of her 7 appointed attorneys. Oh gosh, let's just read the law. Both the U.S. and the Florida constitutions guarantee an indigent criminal defendant the right to assistance of appointed counsel. Okay. The counsel clause of the Florida Constitution under Article 1, Section 16 recognizes the right to counsel as well as self-representation in all criminal prosecutions. Bierke v. State? Burlke. I don't know how to pronounce that one. Oh boy. Forfeiture of right to counsel. A defendant in a criminal case can forfeit a right to counsel, a court-appointed counsel. Forfeiture is an extreme measure that flows from the defendant's abuse or manipulation of the right to counsel. Oh, yes. Call her out. Defendant's abuse and manipulation of right to counsel. Yes. Call her out. And results in the defendant being required to represent himself or herself, even though he or she has not waived counsel and may still want legal representation. Citing Commonwealth v. Means, Massachusetts. Forfeiture is a judicial response that adapts the course of the legal proceedings of the defendant's choice to engage in misconduct that undermines the legitimate exercise of the right to counsel. As set forth, defendant's recalcitrance to the attorneys who were not conflicted out, Padilla, Bankowitz, Hobson, Cashman. So these are the 4 attorneys that decided to withdraw because of reconcilable differences. 4 attorneys in the past 2 years. Antagonism, hostility, and attacks on the professionalism of Padilla, notably over a year after the fact, see footnote 9 above, of Bankowitz and of Cashman, and personal attacks on Padilla, Bankowitz, and Cashman. Each of these attorneys were required to withdraw. I mean, if you find out that your client wrote a 58-page fucking letter where a good amount of it, sorry, not a good amount of it, but like the good beginning portion of it was just trashing you, yeah, why the hell would you want to represent her? It has become apparent to the court that the defendant will not permit herself to be represented by anyone. Ooh. Additionally, the withdrawal of 8 different attorneys, 7 of which were court appointed, leads to the determination that the defendant has forfeited his right or her right to counsel. Under Florida law, the facts at bar amount to a binding forfeiture of the right to counsel. Jeez, I don't know. For some reason, I thought they would give her another chance. I don't know. I thought they were going to give her another chance. But you know what? Fuck it. Let's move on. As the court finds the defendant has forfeited the right to court-appointed counsel under Florida law, there's no obligation to conduct a Forfeiture hearing or to otherwise warn a defendant of the dangers of proceeding. A Forfeiture hearing. Forfeiture hearing. Forfeiture v. California was a case in which the Supreme Court of the U.S. held that criminal defendants have a constitutional right to refuse counsel and represent themselves in a state criminal proceeding. I mean, they did warn her multiple times, like, hey, like, if you don't get along with this court-appointed attorney, you might have to represent yourself. Do you want to represent yourself? You know, it's going to be kind of a shit show if you do. I think they warned her about 2 or 3 times already. So at some point, they must have just been like, you know what? Fuck it. We're not giving you a court-appointed attorney. You're just going to have to represent yourself. Jesus. That's not, I don't know. That just doesn't seem fun. It doesn't seem fun at all. They all said, see you next Tuesday, Sarah. Boone educates the judge about the law in 50 pages. I think my vocabulary is a bit more vulgar than yours. In general text, I have a potty mouth. I can't wait. I haven't looked at if they set a trial date yet. Hi, Thundercat. How's it going? Never represent yourself. Yeah, it just sounds like a shit show, you know? Even if you know what you're doing, it's probably better to have someone come in and from an outside perspective, you know? Oh, boy. So now what? The court can find a waiver by conduct to the right of counsel. Waiver by conduct requires the defendant be warned about the consequences of their conduct, including the risk of proceeding. Yep, they warned her quite a few times. February 9, 2024, defendant was twice advised that another court-appointed attorney may not be provided. May 10, 2022, defendant was advised about the dangers of self-representation. February 9, 2024, defendant was advised about the dangers of self-representation. As of February 9, 2024, the instant case has been continued 16 times. 16 times. Jesus. I mean, the murder was committed, or sorry, the alleged murder was committed 4 years ago. Jesus. As of June 26, 2024, this case has been pending 4 years, 3 months, 5 days. Ooh, taking the page out of Sarah Boone's book. They need to count down the hours, the minutes, and the seconds as well. That's how she does it. From the date of the filing of the information on March 23rd, 2020, actions speak louder than words. Although defendant's word seemingly revealed desire to go to trial, however, I think she was trying to delay it as much as she can. However, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over, allowing defendant to her 8th court-appointed attorney. Her 9th attorney overall will only serve to delay the case further. Encourage the defendant to persist in efforts to prevent the resolution of the case on its merits. The concept of which was first brought defendant's attention on May 10, 2022. Defendant complains that Bankowitz and Hobson, 2 court-appointed attorneys, failed to meet and communicate when defendants provided court-appointed counsel who will meet and communicate, Cashman, and the ways and means of meeting and communicating are unacceptable to the defendant. Under the Florida law, the facts at bar amount to the binding waiver of the right to counsel. Orders and adjudges as follow. Ooh, Patricia Cashman's probably like, yes, thank you, I'm free. Getting rid of these shekels. 1. Cashman's motion withdrawal as counsel filed June 11, 2024. Granted. Oh, gosh. As a condition of Cashman's withdrawal, Cashman shall provide the court an order for costs to obtain transcripts of deposition for the two witnesses Cashman depose. Upon completion of the transcripts of depositions, the depot's transcripts shall be sent directly to defendant Sarah Boone by Cashman at the Orange County Jail. Thereafter, Cashman shall file notice with the court reflecting that the depositions transcript were provided to the defendant Sarah Boone, and such notice shall include the date sent and the address of the defendant Sarah Boone. Good luck, Sarah Boone. I mean, you know what? She spent all that time studying and learning all these legal terms and stuff like that. She's got this. She'll be fine. She'll be fine. Number 3, Sarah Boone has forfeited her right to court-appointed counsel. Number 4, alternatively, defendant Sarah Boone has, through waived by her conduct, her right to appoint court-appointed counsel. The trial management conference shall remain specially set for Tuesday, September 24, 2024 at 1:30 p.m. Let me write that into my, I don't know if I have that. I felt like with the Sarah Boone stuff, I just stopped writing dates because everything just kept getting moved and all that crazy shit. Let's see. September 24. Oh, no, I have it on here. Case management for Sarah Boone. Okay. At 1:30 p.m. This case shall remain specially set for trial for the 2-week trial period beginning Monday, October 7, 2024. Yep, I got that date. And will not be continued for any reason except extraordinarily good cause, and such extraordinary good cause shall not include retention of counsel by the defendant. Wait, really? So they refuse to continue this for any reason except by extraordinary good cause. And such extraordinary good cause shall not include retention of counsel by defendant. Wait, so even if she decides to retain counsel with her own money, that's not a reason for a continuance? Or am I not understanding that sentence? Shall not include. Yeah, that's what it's saying. Like, even if she does hire an attorney, she can't ask for a continuance. Oh boy. Number 7. Any and all pretrial motions in this case must be filed no later than the close of business on Monday, July 22nd, 2024. Oh my God. Good luck, Sarah Boone. You have until July 2024 to file all your pre-motions. Oh gosh. Done and ordered. Listen, Judge Kranick is like, listen, I know what Judge Wooden went through. I am not putting up with any of this bullshit. I know your history. I know your letters. I've read them. Maybe read them. And yeah, we're just going to move on with the trial. You're not going to fuck with me in my courtroom at all. Jesus, he just put his foot down. Judge Kranick. Jeez. I hope there'll be a time limit for Boone like there was for Debbie Heard. I worry this trial will go on and on and on and on. Time limits. Yeah, I don't really know much about time limits for criminal cases. I mean, I'm assuming there's like a time constraint for the state, but I mean, they usually give leeway, right? Because a Karen Reed trial, wasn't that only supposed to be like a month? 5 weeks, maybe? 6 weeks, maybe? I think I heard 6 weeks, and it ended up being more than that. It ended up being like 8 or 9 weeks. She has 3 weeks to follow everything. Wow. Oh, gosh. I wish I could see the look of her face when she read this order. Oh my goodness. Hi. Is it Ellen? Eileen? Hello, how are you doing today? I'm not too sure if it's an I or if it's just like double L's, but hello. How's it going? Oh geez. Okay, so let's recap. So Sarah Boone has had 8 attorneys. Now, half of them was because there was a conflict of interest. The first attorney withdrew because Sarah Boone was going to hire a attorney out of her own pocket, I'm assuming. But 2 years after working with attorney number 2, for some reason, he decides to withdraw. And we find out it's irreconcilable differences and ethical concerns. Then we had attorney 3, 4, 5, and they all withdrew because there was a conflict of interest. I think from what I've remembered, some of them had a conflict of interest because of the victim, or there was an attorney that represented the apartment that Sarah Boone was living at. And I know the apartment was like going after her to collect the rest of the rent or like kick her out or something because she broke the leasing contract by, well, possibly murdering her boyfriend there. So I remember those 2, and there might have been another one that had relations with the victim as well. When I say relations, I think it was just like some Maybe they represented him or in something else. Then we had Mr. Bankowitz. And Mr. Bankowitz, I remember, because poor Mr. Bankowitz just looked like this poor old man. You know, every time when he came into court, he just looked like this really old dude, you know. Bankowitz tried to withdraw, and the judge was like, no, we're going to keep you on and, you know, work shit out, right? So Bankowitz tries to work with Sarah Boone for about 8 months. And he's like, no, you know what? I can't. Motion to withdraw, irreconcilable differences. That was finally granted. And then we had attorney number 7, which I completely forgot about, Winston Hobson. Mr. Hobson, poor Mr. Hobson. I can't believe I forgot about him. Mr. Hobson worked with Sarah Boone for a couple months. Maybe a little over a couple months, okay? A few months. And also decides to withdraw as well. Same thing, irreconcilable differences. Also ethical consideration. And then finally we get Patricia Cashman. And we don't really hear from Sarah Boone for a little bit. Or like, oh, okay, maybe things are working out with Patricia Cashman, Sarah Boone. Every time when I check the cases, it seems like things are moving along. Like Patricia Cashman is doing depositions, you know, she's like doing things. And I'm like, okay, good. We're finally going to have the trial. Let's move on. All of a sudden, when we have the hearing, well, now we have dirty laundry that's being aired. Sarah Boone is also calling Patricia Cashman all these names, saying that she's a liar. Sarah Boone wants to be out on bond. You know, she said that like she was being lied to, that Patricia Cashman was lying to her brother, blah, blah, blah. A whole bunch of stuff came out. And you could tell that Patricia Cashman wanted to withdraw, but she didn't follow the motion because she was telling the judge, like, hey, you know, like there's some issues between me and her, wink, wink. And the judge is like, all right, well, let's just set a trial date and yeah, good luck. And at some point, Patricia Cashman probably got wind of that 58-page letter and then read the context of it and was like, you know what? Fuck this. I'm motion to withdraw. I don't want to be with this client. So because the court has threw out all the different attorneys that Sarah Boone has cycled through, because I guess the court has, you know, warned her multiple times, like, hey, you might have to represent yourself. Hey, like if it doesn't work with this attorney, you're going to have to represent yourself. But, you know, we want to caution you, representing yourself is going to fucking suck. You don't know the law. You're not going to know what you're doing. It's going to be a huge burden on you. But they kept warning her. And at some point, you know, the new judge, who is now Judge Kranick, is a no-nonsense judge. But, I mean, even though a lot of this shit happened under the presence of a different judge, I mean, we are on attorney number 8 now. 4 withdrew because of irreconcilable differences. So this judge is like, we're setting the trial date no matter what. We're not going to move it. I don't care for any reason. Unless there's something, you know, maybe, you know, something big, maybe we'll move it. But Sarah Boone, if you hire another attorney, it seems like they're not going to push out the trial date even for that. And it seems like Sarah Boone has a couple weeks to put in all her pretrial motions, and that's her deadline. So good luck with that. I mean, honestly, if you're an asshole to people and you think that people are you think people have to work for you just because, oh, you know, they're a public defender, they have to defend me no matter what. They're not going to have to listen to you and be told what to do just because you think you're smarter than them. I guess we're going to read a letter about this. How long was Charles Ong case delayed by him? Oh, I'm not quite familiar with that one. I do not know. You watch a special on him? It was a long time. Hong Kong. Oh, serial killer in the US? Oh, I've never heard of this guy before. When was this? Oh, during the mid 1980s? Jesus. Wait, it's a dual serial killer? I've never heard of this guy before. I didn't even know there was an Asian serial killer. Boone's complacent stuffy cheeks, groundhog face, along with already triggers me. Ha 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 ha. Patricia was actually doing her thing. Sarah wasn't participating or cooperative. I mean, and she said that she was walking out on their meetings. It seems like Sarah Boone thinks lawyers can say anything in defense of the client, which isn't true. Lawyers with good ethics can't lie in court about facts they know to be false. Seems like Sarah needs brushing up on what attorneys can and cannot do. But she seems like I don't know, she just seems like the type of person who'd be hard-headed. Even if you had someone with like a good educational background, good experience, and they tell you, no, I can't do X, Y, and Z, Sarah Boone's like, no, I know you can. It's like, okay, so what's your basis for that? Because I know you can. Duh. Like, you know, Sarah Boone just seems like that type of person. Oh, man. Sarah, please define FAFO for us. Oh, it's in California. Apparently, one of these over 50 pages, Boone drew a world map. She didn't draw a world map, but she Xeroxed in like the map of the US, the map of the world, and had a bunch of these condescending vocabulary definitions for the judge because she thinks the judge doesn't know the definitions of these basic legal terms and stuff. Oh boy. Meninjas, how are you doing today? How's it going? The behavior panel, but chipmunks are supposed to be cute though. I can't throw Sarah Boone in with chipmunks. Chipmunks are cute, adorable. They have high-pitched noises. They're just cute little dudes. No, Sarah Boone is I see the cheeks though, but oh man. Okay, so that's gonna be a shit show. I'm sorry. I like I said, I don't like it when people who don't know what the fuck they're doing represent themselves, because like I said, it's just I don't know. It feels like you're just watching some sort of like courtroom entertainment at that point, you know? And things are moving more slowly because they don't know what they're doing. The judge has to stop and explain things to them, and it's just like, oh, could we just get on with this? I don't know. It's gonna be a mess. But does she deserve it? Yeah, it seems like it. It seems like she does deserve it. So I wonder if she was hoping that she can at some point just be like, hey, the court system has fucked up so much because they appointed me all these public defenders that were horrible, bad. They were unethical. They wouldn't listen to me. They wouldn't meet with me, blah, 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 that you should just dismiss all the charges and just let me go. I don't know if she was like maybe she was trying to aim for that. Because I don't know why you would be so adversarial to someone who's going to defend you in trial. Right? You want to be on their good side. You want to be in good terms with them because they're going to fucking defend you. And your life literally depends on them. But she just seems like she was really ungrateful. And it was just like her way or the highway. When she was talking to the cops at the department that day with her hands under her on her chin and her chubby cheeks. Hi, Corey. You ready for the weekend? This is amusing after, the Reed stuff. This is sort of amusing, after the Reed stuff. That is... I don't know. I feel like my mind is just so anxious of the Reed stuff, where I'm just like, I just want to know what's going on. I want to know what's happening, but I sure as hell can't wait for the jury to spill the tea on everything that's going on in deliberations afterwards. I want to know what's going on. Just popping in and lurking. Thank you. Is this a new case? This is a case that we've been covering for the past, couple years now. It hasn't made it to trial yet. It's a Sarah Boone suitcase murder trial, or soon to be trial, that's going to happen in a couple months. But the reason why this case is just so bad, because you can see her on the body cam footage of her demeanor. You can see her when she's being interrogated by the police, and then she took a video of her boyfriend zipped up in a suitcase, and he's like begging to get out, and she's just laughing at him, and she's drunk, slurring, just laughing, and she's a fucking liar. So she just says, I don't know, she doesn't think she's a murderer. See, not everyone knows Sarah Boone. Charles Ong, 10 years and 7 years after extradition. Oh, did he escape and go back to Hong Kong or something? If she was an attorney, the open with Sarah Boone is a deplorable person. I don't like her. You're not going to like her either, but... Oh my. Yeah, so her trial is scheduled for September, it says. October. But we're gonna have a very, very busy third quarter. So we have Alec Baldwin, which I want to watch parts of. I don't know. Well, actually, it's only 8 days. I'll probably watch the whole thing. 8 days. I kind of want to watch it. But I think a lot of the testimonies might be similar to the Hannah Reid case. But I do want to pop in for Alec Baldwin. His trial starts in like a week or two. And then we have, Alexi Treviso is going to happen. When is that? August. Yeah, that's August. And then maybe Adelson stuff, and then Sarah Boone stuff. It's going to be pretty busy. Charlie Ong was a Canadian, if I remember correctly. 10 attorneys, he decamped to Canada. Oh, so 7 years after that, they got him back. Try to run away, huh? All right, y'all. So for the YouTube stuff, that's it for today. I was in the middle of reading Canton stuff because I thought that was interesting. Let me go back to, let me see. Do I still want to read it? I was reading this article, but I think I'm done reading this article. And then we got to the Sarah Boone stuff. Adelson. Yes, definitely we'll cover Adelson. I just want to know, at this point, can Donald Adelson just be like, you know what, fuck it, Charlie, you're going to be in jail for a very long time. We're just going to throw you under the bus. But I mean, Donna probably thinks that she probably has like, you know, a little amount of time to live. So maybe she'll throw herself under the bus. She should have just done that. Throw herself under the bus and save Charlie or something. But now it's too late for all of that. I don't know. What's interesting to me is Donna Adelson also hired Charlie's attorney to represent her as well. And I think maybe like a local attorney. Oh, but the Adelson stuff will be pretty crazy because a lot of people are waiting with bated breath, you know, like, oh, what about Wendy? Is anything gonna happen to Wendy or not? He managed to call a juror's phone and called. Wait, what? He got a juror's phone number? Was he in jail at that point? How? Oh, this is what I wanted to read to you guys. Sorry, can we go back to Karen Reed really quick? But you're welcome to talk about any topic you want in the chat. So this is the article I was reading, and I thought it was interesting. Usually means I'm side-eyeing. So the title says, Karen Reed's murder trial delayed as new evidence from the feds come in. This was in February, okay, 4 months ago. The Karen Reed murder trial has been delayed by at least a month after thousands of pages of new evidence was received from federal prosecutors. Monday was supposed to be the final hearing before the beginning of the trial. Reed is accused of killing her Boston police officer boyfriend in Canton, Massachusetts back in 2022, but Norfolk Superior Court Judge Beverly Cannoni set a new schedule for the trial after the hearing from the U.S. Attorney's Office of Massachusetts. She set a new trial date for April 16, just over a month after the previously scheduled date of March 12. But Reed's attorney said they would likely need more time to comb through all 3,000 pages of evidence they received from federal prosecutors with a separate legal process to go through in the federal court system. Jackson says, an April 16 jury trial is not realistic. Cannoni said she understood the position, but advised him to be ready for the trial regardless. I feel like she always does, like, yeah, I understand what you're saying, but no. While Jackson characterized the new evidence his team had time to review as being exculpatory for Reed, so again, probably the ARCA people, and entirely new, prosecutor Laura McLaughlin disputed that characterization. Oh, it was the prosecutor that said, I thought it was Mr. Lawley. Well, they're on the same team. So Laura McLaughlin disputed that characterization, saying at least 90% of the evidence is consistent with prior testimony in the case. I want to know what that 90% is, because remember, the 10% that's not consistent with their case, the state's case, it's going to be the ARCA stuff, and that's a huge effing issue. Reed was in court for a hearing on Monday. Last week, prosecutors said they have DNA evidence that links Reed to John O'Keefe's death. I mean, they're talking about the hair. Documents indicate that a piece of O'Keefe's hair and pieces... Okay, so this is what's interesting. Documents indicate that pieces of O'Keefe's hair and pieces of the glass from the drink he was carrying was found stuck under Reed's SUV. I don't know if they just have the quote wrong, but wasn't the pieces of glass just sitting on the bumper, not stuck underneath the SUV? Did they just fuck this entire quote up? And then also, remember, the glass, I still have questions about the glass. I need to go back and listen to that one person's testimony about the glass not being consistent with the glass that John O'Keefe had that night. The documents also paint a picture of the relationship turmoil. They said Reed was angry at O'Keefe for allegedly cheating on her. Also on Monday, the controversial blogger Turtle Boy has been expected to be in court for a hearing, but the appearance ended up being postponed. Aidan Kearney was just released from jail on Friday after being indicted on 2 new charges last week. Kearney appeared in court for Reed's hearing Monday afternoon. The charges are for an assault he is accused of back in December. It landed him behind bars for 2 months. Who was there for 2 months? Kearney has been the focus of investigators given his online coverage of the Reed case. He's facing multiple charges of intimidating witnesses and investigators. So what I found interesting was this right here. Pieces of the glass from the drink he was carrying was found stuck under Reed's SUV. I wonder if the state even knows what they think even happened. I feel like they keep changing small little minor details. Or they're just not saying things. Could be a misquote. But then at this point, didn't the state know that the pieces of glass on the bumper didn't match the glass from John O'Keefe? Because now I need to go back and look at my notes to see when the testing was done. Was the hair under the SUV? No. The hair was on the... It was on like the... They call it the wheel well or something? but I think it was like on like the side part, like near the bumper or something. But it was just a piece of hair. I don't know. So weird. And then this part too, that only 10%, only 10% was inconsistent with shit. Saying that at least 90% of the evidence consistent with prior testimony. It's like, okay, but the 10% that's not consistent are some major it's some major shit. But I do want to go back to the glass of the bumper thing. Like, a lot of us said the glass didn't match, right? But I'm like, did we hear incorrectly? Because if it did match, then Lolly would be singing that in closing arguments. And he wasn't singing that in closing arguments. I think Lolly knew what to avoid in closing arguments. What inconsistency to avoid. All right. And then I read, this is Proctor stuff. I also read this too, which I thought was interesting. This is the last article I'm going to share with you guys. So this is from March 14, 2024. Lead detective in Karen Reed murder case under investigation. Does anyone know how old Proctor is? A trooper who handled key evidence and witnesses in the murder case against Karen Reed is now the subject of an internal investigation by the Massachusetts State Police. State Police confirmed Wednesday that Michael Proctor is being investigated for a potential violation of department policy, but they would not comment on what caused them to probe one of their own. I don't know, probably all these people in the news outlets reporting about Mr. Proctor. Sources tell NBC 10 Boston the investigations in connection to the Reed case. Proctor remains on full duty. Is he still on full duty? While the internal investigation unfolds. And the Norfolk County, because I feel like just put him on desk duty. I don't know if I would want him going around, doing his detective stuff. The Norfolk County District Office Attorney's Office told NBC 10 Boston the internal affairs investigation had not impacted Proctor's case assignment. It did not impact his case assignment? How? Proctor was one of the investigators, not just one of the investigators, the lead investigator against Reed, who was charged with second-degree murder in 2022, death of her boyfriend, Officer John O'Keefe. Prosecutors allege that Reed hit O'Keefe with her SUV, left him to die, while Reed's defense attorney had long claimed she is framed in a wide-ranging cover-up. And what's interesting is that the cover-up thing was mentioned, because I thought the cover-up was mentioned maybe like years after she was arrested, but it was actually like just a couple months afterwards. I think it was in June. Yannetti brought it up in one of like the hearings or something. The internal investigation came to light just one day after the bombshell hearing in Reed's murder trial, in which her defense attorney alleged Proctor never fully disclosed his personal relationship with multiple people involved in the case. This includes the Albert family, who lived the home and the property where O'Keefe's body was found. Texts allegedly showed Albert's offer to send Proctor a thank you gift when this is all over, and just days prior to O'Keefe's death, Proctor had allegedly asked the Alberts to babysit his child. Yeah, I don't know. That's a weird one right there. Quotations from Alan Jackson. So now we have a lead investigator from Massachusetts State Police literally discussing the exchange of gifts between the Albert family on one hand and the Proctor family on the other hand as a thank you, their words for helping the Alberts out of a jam. The gift thing, I was just like, okay, it doesn't sound too bad, but if Proctor was such a, if he was such a smart person, we know he's not a smart person. I just feel like you would just be like, no, I can't take gifts. Like, why wouldn't you say that? But instead he was like, oh, you can give it to my wife. It's like, don't you realize that could look kind of bad? Anyways. It's not yet clear what impact, if any, the internal affairs investigation could have on the case. Shane Rodriguez, a professor at the Massachusetts School of Law, said a finding of wrongdoing could have a huge implication for the DA and their ability to prosecute this case. Beyond that, he said, it could have an impact on later cases separate from the Karen Reed trial. Oh, that would be like a shit show mess. State Police Association of Massachusetts has declined to comment on the investigation into Proctor. Attorney for Reed declined to comment. It's NBC 10 Boston Thursday. I've read this, and what else did I read? I think that's about it. Oh, I read one. It was like a timeline of how everything happened, which I thought was really interesting, actually. I don't know if you guys would think it's interesting. Let me see if I could find it. I know I said this was the last article. Timeline. Was it this one? Oh, I think Karen Reed gave like a mini interview. Or she just spoke to the camera. I wanted to see what she said. Mansfield woman, when this is all over, it's like fishy up front. I think he should have just been like, I'm good. I can't take, I'm good on gifts. Like, no, thank you. This is my job. This is my duty. This is what I do for a living. You know, but no. Can't expect too much from Mr. Proctor. Yeah, so Yannetti from the beginning has said that there was something fishy going on. Because I wonder if it was like one of those cases where, like, as evidence came out, they kept changing their story, but it seems like their story has been pretty consistent from the get-go. Yannetti said that he has evidence it was in a different condition after police impounded it, and said O'Keefe's injuries are inconsistent with being hit by a car. Oh, this is not what I was looking for. It was like a timeline, which I thought was really interesting to see how things unfolded. And then Karen Reed spoke to the cameras very briefly, and I just wanted to know what she said. But I don't have it up here. Maybe I read it a different day. Possibly. Okay, well, that's pretty much it for YouTube stuff. Thanks for hanging out with me today, guys. If you guys missed it earlier, we covered the Karen Reed stuff that happened today, which nothing much really happened. Jury has been sent home for the day. They'll be back on Monday to deliberate. And then we just randomly segued into Sarah Boone stuff. Sarah Boone is going to have to represent herself. And the judge said, no matter what, we are not going to move the trial date, even if you find an attorney to represent you. Which I don't know who the fuck is going to represent her. But I don't know. Maybe there's someone out there who likes a challenge or something. Proctor is still lead investigator. That's why the DOJ is looking into things. Not sure why the feds are. RICO involvement with Albers, McCabe's, lots of cops. The wording for the GIF, read that. Very problematic. It's coming from a cop's ex-wife. Yeah, he should have just denied it. I don't know why he didn't. Like, I'm sure, like, maybe the civilian didn't know any better, but I mean, he should have been like, oh, no, I'm good. But whatever. It's Proctor. We know he did a lot of stupid shit in this investigation. Give Corgi your thumbs up here. Here's mine. Thank you. I will take your thumbs up. Thank you. Yoink. But yeah, that's it for today. We covered Sarah Boone, and I'll probably just make the Sarah Boone stuff into a video in case you guys missed it earlier, and I'll mush it together. But other than that, I hope you guys have a good weekend. Take care. I will see you guys later, and I'm just going to continue streaming on the Twitch. But for YouTube, thanks for hanging out. Have a good one. Yeah, I don't know. Hopefully I won't dream about any of this true crime shit anymore. Okay, I don't want to see Yannetti, Jackson, Lolly. I don't want to see any of these people in my fucking dreams. Leave me alone. And it's weird because I usually do not dream about any of my cases. I never dream of any of the cases, any of the trial stuff. Even when I covered Depp v. Heard, I don't think I dreamt about any of that. But the Reed stuff must really be giving me like some sort of anxiety or something. I need better dreams. Yeah, that'd be great. All right, guys, have a good one, and I'll see you guys later. Bye, YouTube. Peace out. Okay, now we're just live on Z.